Good morning, ma'am. Are you Relacia Mouton?
Yes, ma'am. Sure.
And Ms. Mouton, in cause number 25 DCCR 0907, before we go forward, I'm going to take judicial notice of the court's file. It looks like there was an evaluation done by Dr. Capon last year with regard to competency, and that we received that report back in October, and Ms. Mouton was found competent to stand trial. Is there...
Did this in January 20th.
The competency report's from October.
You found her competent January 20th.
That's what my file reflects also, Judge.
Okay. Maybe we didn't get her back. I don't know why.
She didn't.
There's a lot of things there.
Hold on.
I don't think she was ever taken anywhere.
No. So I don't know why. Anyway, found competent based on that report. There hasn't been any other reports that I know other than the Dr. Capon report from back in October. And so any other issues at this point with regard to competency?
No, Your Honor.
All right. So in cause number 25, DCCR 0907, Ms. Mouton, you're charged with a second-degree felony offense of assault on a peace officer. And what that means is that if you go to trial and you're found guilty, the range of punishments between 2 years and up to 20 years in prison. Do you understand? I need you to answer out loud for the record.
I understand.
Thank you. And then in cause number 25, DCCR 1466, you're also charged with assault on a peace officer. This one is from August 17th of 2024. The first one that I read out was actually from May 5th of 2025. So this second one, same thing, is a second degree felony. If you're found guilty, the range of punishments between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1467, you're charged with the state jail felony offense of possession of a controlled substance from August 17th of 2024. And in that case, that means that if you went to trial and you were found guilty, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand that?
Yes, ma'am.
And then in cause number 25, DCCR 1468, you're charged with assault on a peace officer, and this is from that same date of August 17th of 2024. Again, if you're found guilty by a jury, the same punishment range applies, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then the last case is 26 DCCR 0120. You're charged with possession of a controlled substance, a state jail felony, from August 8th of 2024. And in that case, if you were found guilty, the range of punishments between 6 months and up to 2 years. Do you understand?
Yes, ma'am.
I have here on the tablet plea bargain rejections that you've signed with Mr. Rojas that shows that the district attorney's office has made offers in your cases if you wanted to enter pleas of guilty for 8-year term in prison and on all of those assault on a peace officer cases that would run at the same time concurrently, and then a 2-year sentence in the state jail prison on those two.
The offer was actually we would dismiss the state jails, Judge.
Okay, so there would be a dismissal in the 2 state jails with, I'm going to make that notation.
Because I just signed paperwork refusing 2 years with both of those.
You did. So obviously the bigger cases are the 8-year terms. So what the offer is, and so that we're all on the same page, it would be 8 years TDC on the 3 assault on a peace officer cases with dismissals in the 2 state jail cases. Does that change your mind?
No, ma'am.
Okay. So you have every right to reject.
Probation.
Hang on. So you have every right to reject those offers. I just need to make sure that you understand what the possible consequences are if you go to trial,
Yes, ma'am.
what your options are if you wanted to enter a plea of guilty, and you understand all of that.
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get them set for trial. Ms.
Can I
Mouton,
get the lawyer?
Listen. Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am. I thought you was trying to make me keep him.
Well, it wouldn't be the worst thing because he's one of the best lawyers we
I
have.
understand.
So, Mr. Rojas, you're released, and Ms. Mouton will give you a new attorney. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff. Also, hold on, come back. Mr. Smith, do you anticipate there would be any reason for that offer to change?
Judge, I thought that was a very generous offer.
So I do want to make sure you understand that just getting a new lawyer doesn't mean things are going to change. The offer is what it is, and so there's not going to be any change just because there's a new lawyer.
I've seen the tape, and it's not enough on the tape to show that I deserve 8 years.
All right, but that'll be up to
trouble in 20 years.
that'll be up to a jury. That's 985 and 24 DCCR 1790. Mr. Williams is charged with capital murder as well as aggravated assault causing serious bodily injury. And what is the announcement, Mr. Cashin?
We need to take care of some housekeeping matters because the last time we were here, you had ordered the state to provide us with written notice whether they're going to seek the death penalty. And yesterday afternoon when I left my office, I had gotten nothing from the state as to whether or not they're going to seek the death penalty. And I would like that information as soon as possible in accordance with the order that you have.
Mr. Smith?
State's not seeking death penalty, Judge.
Okay, if you'll get that in writing to Mr. Cashin so he has it for his file. That way that gives him the opportunity to know how to move forward. I'd like to get this case, if it's going to be a trial, tried before the end of the year.
Yes.
And so I want to,
I agree.
And there are some other issues, Your Honor. Back when we first came to court, I had filed a motion to quash the indictment because the indictment, from what I understood, was incorrect because it was under a wrong provision and it was for retaliation against the judge. And they have not corrected that in that indictment.
just let me pull that.
Yes, ma'am.
So I think we discussed this, and it's only the heading, which is not substantive. Obviously, the substantive part of the indictment is what the actual charge is, which is the retaliation
Yes.
against Mr. Lewis. It's the indictment itself is not going to be quashed because of what's ultimately a typographical error in the top.
Okay.
I do think it's clean, or for the record, if you want to make an oral amendment, I think that's something we can do today.
Okay. Right from the state.
I think it needs to be correct as well. And it's not 18. I can't remember which one it is, but I'm gonna look. I know we had this conversation.
Yes, ma'am.
Do you remember which one it is?
In the very beginning. Well, I left that file in my office.
That's all right. I can figure it out. Let's see, 19. Go to 1903 A.
Team. I mean, that is correct.
That is correct.
1903.
1903 18 is correct.
It is.
I can live.
There was something that I do recall us having a conversation about, but
Well, it says murder for retaliation, judge justice. I mean,
the
we
judge
can line
justice
through
needs
that.
to be interlineated, but the
Right,
section
that's-
number is actually
Okay,
correct.
that's
Yes.
what I'm,
That's okay.
that need to be delineated.
Any make an oral motion to
We would
do
make
that?
an oral motion to strike that from the.
Okay, and
Hold on. Any objection to that?
no, Your Honor.
All right, give me just a second to get it done before I move on. It doesn't want to give me that option yet. Okay. That's weird. And we need to, would you, make a note on a ticket? For some reason, the one thing that I need, which is the interlineation thing, is not letting me do it. And it has in the past. Okay. So I'm just gonna print it. Yes, and we'll do it that way. Okay, what else?
We recently got an email from Mr. Smith about some discovery and I bought a 1 terabyte drive to be copied, the information that he's referring to.
Okay,
And so I would like that. Then I have a motion to change venue right here, but I need to get Mr. Williams to sign his affidavit, and it will be filed this morning.
okay. So with regard to discovery, y'all can take care of that.
Yes, ma'am.
I don't need to get involved in that. And then once if something is filed with regard to a change of venue, I'll get that set for a
Yes.
hearing within the next few weeks.
Yes.
Obviously, that's something we'll need to get taken care of so everybody can plan ahead
Yes, ma'am.
on what we're doing. So once it's filed, I'll
It'll be
give everybody an opportunity to get ready and we'll get something set.
that'll be
I would
done.
say within 2 or 3 weeks.
Thank you, ma'am.
Okay. Anything else?
That's it for now.
Okay. All right. If you can, if you need him to sign that in front of
Notary.
if you can step over here in front of the clerk, she'll take care of that.
Thank you. Thank you, Judge.
Thank y'all. She's gonna go get her
Notary.
notaries. You're Bobby Clark, and this is cause number 25 DCCR 0802. Mr. Clark is charged with indecency with a child by sexual contact. And what is the announcement?
Judge, this was set to this court date for a status. I think Ms. French had ordered the CPS records.
Hold on a second. I need y'all to all hold it down, please. Go ahead.
Ms. French has, through the court, obtained CPS records. We both have copies of those.
Okay, good.
So I think at this point, we're needing to just set this back on the trial docket.
Okay.
There's already a rejection on
Has there been any change in what the offer was? It looks like it was back in August of last year. There was a rejection of a 12-year term.
Correct, Judge. And I don't know what Ms. French intends to do, but I do know that she is planning to meet with the complainant soon.
Okay.
And we talked about that today. If there is a change, we would obviously bring that to the court's attention
Sure.
beforehand.
So let's go ahead and get it on a trial date.
Just because of the nature of the case, I think.
Yeah, for sure. All right. So Mr. Clark, I'll get your case set on the trial docket. If something changes with any negotiation, y'all just let me know as soon as that changes and we'll get you back in here. Otherwise, we'll see you at the next on the first trial date. Okay. Trying to go back to the bailiff. Thank you.
This courtroom hearing quickly turned tense as defendant Alicia Mouton rejected an 8-year prison deal on multiple felony charges, including several counts of assault on a peace officer. Despite facing decades behind bars if convicted at trial, she refused the plea agreement after the judge carefully explained the risks and confirmed the evidence against her had already been reviewed. Even after being warned that changing attorneys would not change the offer, she stood firm and demanded a jury trial instead. The hearing then shifted into even more serious territory with a capital murder case, where defense attorneys pressed prosecutors for answers about whether they planned to seek the death penalty. The state confirmed they would not pursue execution, but tensions remained high as both sides battled over indictment wording, discovery evidence, and a possible change of venue before trial. Meanwhile, another defendant facing indecency with a child charges prepared for a future trial after rejecting a previous 12-year plea offer. By the end of the hearing, the courtroom carried one clear message: confidence in court can be dangerous when the stakes are this high. Plea deals were rejected, trial dates moved forward, and multiple defendants now face juries that could decide the rest of their lives. The judge made it clear that once those opportunities disappear, there may be no second chance to avoid the consequences waiting.